Now the matter is brought to you in the court in Wakiso. What are you looking for? If these parties, if it has not been filed in court, that is simple for you. You talk to them, reach a memorandum of understanding. Your question is, what do we do? What you do is this. The memorandum of understanding you reach is a contract. You will therefore, any party can sue on any contract. So if the parties reach a contract, you have jurisdiction. When they come back, who will lose in your court? The one who is breaching the contract. In the future, we are trying to see if we can adopt the Kenya experience. But I said the rules are still before the Rules Committee. When the rules come out, parties will be able to register their decision and it will be enforced as a court judgment. But before that happens, apply the law of contract. You'll find a way out. The courts can positively promote mediation agreements and enforce them even before we get the achievement of amending the law. I think the proposal, I think Advocate Toto just talked about mandatory mediation. I think we must come back to mandatory mediation if we want to promote mediation in our system. Thank you very much.
Justice TCJ, you're ending on a very controversial note, but we will leave it there. Your Worship, maybe you can talk about if ULI can be used as a tool for, or as a repository for private mediation settlement agreements. Could that be the future for ULI?
With my short experience with technology, I think there's nothing that's impossible. Like I told you today, the first plea bargain agreement was uploaded onto ULI, and the system could correctly digest it. Give it a summary, give it the issues in that plea bargain agreement, what the court found, and the orders that were given. So I think even with that, it's very possible. With technology, right now, there's nothing that's and actually I want to believe that ULI is many years ahead of Uganda, because with what I have seen, what people think ULI offers, it offers way beyond what it can actually do. So I believe it is very possible, and we just have to take advantage of the technological space. Thank you.
Thank you very much. Judge, your final comments on the questions that have been answered, questions that have been raised, specifically looking at how we can embrace private mediation in the current legal framework.
I think the answer is what my Lord Justice Butera has given. For as long as we don't have rules to govern those private conversations and in the end settlements, the best we can do is to treat the matter as contractual. The parties make a contract and we take it to a court of law to sanctify it. What would stop you from doing that? It's not a suit. You are just saying, this is what we have agreed for the record. We want it in a permanent form. So the sooner government comes up with a policy on agreements of that nature, I think we have to be slow when it comes to taking them to court for enforcement, because lawyers will be there to challenge us. what is the authority. And you will not have any legal backing. So I believe the law which is, I've not looked at the law which is before the Rules Committee at the moment, but that's something we should have done yesterday. Because there are so many agreements, so many settlements which would benefit from this sort of arrangement so that they don't have to go to courts of law now to clog the system. So we have to stick to the law.
Thank you very much, Judge. Ladies and gentlemen, and that concludes our panel with the homework for the DCJ and the Honorable Minister to consider regulations on or rules for private mediations repository. Do we need to register them? Do we need to include in professional indemnity requirements for lawyers some form of incentive for them to ensure that mediation becomes, as DCJ puts it, mandatory? But then I guess that means we may need to have a classification system of knowing which matters must first be mediated before coming to court. Maybe not all matters, but DCJ, I do not want to set aside your determination. But ladies and gentlemen, please, a round of applause to our panel members. Thank you very much. My sincere apologies for my Kenyanness. I can be quite abrasive at times. I'm still learning to be a Muganda, so please excuse me. We do have some certificates for you. Thank you. Would request you to take a photo with us. Honorable Minister, I believe these are for you to issue, kindly. I do not have the powers to bestow. Justice Butera, we had not dismissed you. I'm sorry. Please forgive me. This is the only moment I get to direct a judge, so kindly, please come back. There are more goodies. To thank you for your, to thank you for your work with the judiciary and on ADR, and to request for a photo for the entire panel, which incidentally also includes me, as I welcome the next moderator. FG, where are you? Senior Counsel Francis Gimara. I'm sorry, I understand that the program has changed, so His Lordship Justice Andrew Hauka, kindly come and introduce the next panel.
Tony, kindly, please, we need the next speaker on the screen. Tony. We need the next speaker on the screen, Tony, please. Technology, we can't see Professor Singh here. I can see him here. My brother, Professor Singh, you are most welcome. Professor Singh taught at Pepperdine University for many years. He holds a PhD, global arbitrator, mediator,
He's traveled in many countries, over 65 countries, doing nothing but mediating cases. Professor Singh in the room, you have many familiar faces. I'm sure you are excited seeing Honorable Norbert Mao here. I don't know if you are able to see him. Solicitor General Emeritus Francis Atoke, Deputy Chief Justice Emeritus Richard Butera, all these were your students at Pepperdine. Singh has done a lot of work in cross-cultural mediations. I have personally not come across somebody who is so knowledgeable about this subject, better than Professor Singh. Kindly put your hands together to welcome Professor Singh. Prof, you have the floor.
Thank you, my friend. Thank you, my friend. Thank you. Mr. How it's a pleasure to see you again. I had a chance to hear Justice Butera as well, and the honorable delegation. I can hear little echo. I hope you all don't hear it, and that's more important. Okay, thank you. Thank you for fixing that. I am honored to be back. I wanted to be in person, and I apologize I couldn't do that in person because of some global issues you can see, I hope, must be bothering you as they're bothering me, and many of us. I will keep my remarks very short. So if you can give me attention for next 10 minutes, I think I'll take you on a journey of mediation. Why are we here today? And the amazing discourse that the honorable justices, jurists, and global thinkers were having in the last panel, as beautifully moderated by my sister from Kenya, who talked about culture at one point, saying how Kenya is different than Uganda. I love that moment. Let me answer 3 questions for you. Question 1 is, what is mediation? Very briefly, not academic, practical definition. Question 2, that came up in the last panel, mandatoriness or voluntariness. What does that mean? Question 3 is, how do we manage difficult people, or should we? Is that something we should think about? In other words, power of mediation, which brings me to the conclusion today, which is coming to an agreement in mediation. So let's jump into all 4 very quickly. Again, my promise to keep it short. I know it's on Zoom. I wish I was there in person. And to everyone who has taken my class, an honor to be one of your teachers. Though I learned a lot more from you than you could have learned from me. Question 1 is, what is mediation? Legal definition is there. You bring 2 people together, you bring 2 or more people together, you listen to people, you empathize, you rephrase, you paraphrase, you break an impasse, you come to a consensus. But is that it? Is that what mediation is? Or is mediation a movement? Is mediation an idea? Is mediation a concept? Is mediation a flow of thoughts? Is mediation something that we all have to imbibe to be able to output in today's conflict-ridden world? The world that has unfortunately been controlled by bullies internationally. Bullies that have held some important positions in different nations. And without respect to laws or sovereignty, those bullies have created chaos. I wish we can say, let's put them in mediation. But the question is not that. The question is why we are not in mediation and why we are in wars. My simple answer to that is the following. We are not in mediation, we are in wars because we have not given courts enough power to lead movements on mediation. Honorable judges in Uganda who have taken some of my training, honorable judges in Rwanda, honorable civil servants in Ghana, honorable High Court judges in Kenya, all of the people I've touched lives with, I've learned that there's power, there's vision, but the question is there an opportunity? That's different. An opportunity is different than power and vision. We need to create more opportunities. The judges need to create more opportunities. And I trust, having known many of you, that you are doing that. Having heard you in the last few minutes, you are doing that. So I applaud that. Number two is the role by citizens, people. People have to adopt mediation. They have to accept mediation. They have to say, fighting is not the way. The way to resolve is by talking, by listening. Number three is culture. We have to change culture of organizations, of systems. Culture of law firms. If a law firm picks up a case and wants to litigate, what stops it from litigating will be the culture, which means the leadership in the law firm. If one leader in the law firm says, I think we should always try to mediate such cases, the culture will change. Number four is education. We have to work with law schools. Mediation, if not mandatory as a settlement option in court, the earlier discussion, I think at least should be mandatory in an education system, as a law school class curriculum. And that is powerful to think about. And number five and last point is political power. India, where I was born and very proud to belong to, and going to do a big conference there in August, is a country where recently we have mediation law passed. And that mediation law has given sanctity, power to billions of people to treat mediation as more than a voluntary process, more than consensus building process. It has trying to become part and parcel of Indian legal system. Are your countries doing that? Not just introducing mediation as a civil dispute resolution body, which I know some local laws do, as the Honorable Justice earlier was mentioning before me, is it mandatory, or what are the teeth? What is the power of that process? How do people see it? How much sanctity is given to that process? Anyways, that was the first question. What is mediation? Not just a theory, it is practice. But let me conclude the question by answering this. Why today people are competitive at international level and not collaborative? Because we are late. Because we forgot or ignored, I would rather use the word ignored, African wisdom of resolving conflict within before we jump out. And that within, when you have conflict within, it comes out at a global stage. Let's go to question two. A small question. I heard a discussion on it being mandatory. I need to mention it briefly. The question is why mandatory, not should it be mandatory. Let's go back. Why it may or may not be mandatory. And it's a beautiful question because the thought is because we still don't have a mental shift, a mental attitude shift towards mediation, right? Globally, not just locally, not just regionally in Africa, globally, we're still struggling to make mediation the number one thing. People want to go to litigation court, people want to go to arbitration, international arbitration, and somewhere comes mediation. And this mind shift change can change people's life. Just like the mind shift change of an aid being stopped can impact 5 million people today. Just stopping one kind of aid, and you probably know what I'm talking about, can impact 5 million people plus. So it's in your hands, you being the leaders in the room, you being the leaders of your countries, you being the leaders on judicial sector, on legislative sector, on government sector, and as non-government sector. I request you, what are you doing? I'm going to ask you the question. What are you doing to change the mindset? Not just yours or your organizations, at a larger scale. That's the thought I want to leave you with. What are you doing to change the mindset? Because we all need help. We're all brothers and sisters in this. One of us cannot do it. We need an army of peacemakers. When there's an army of combatants, we need an army of peacemakers, right? So the more we teach, the more we involve people, the better we are as civilization. Which brings me to the last 2 points. In fact, it's 1 point, but broken into 2 points. So the third point I have is, what are some advanced things we have to think about in mediation? So first, I'll start with easy. Somebody recently asked me to speak on AI and mediation. And I said, I'm not worried. The human element of connection, the human element of empathy, the human element of reading each other, AI is capturing it, trying to capture it. But sometimes what we are not ready as humans, we control the game as of now. Mediation is that human element. It is that connection. It is about that connection. But I said it's easy. So what's difficult? That same thing is also difficult, human element, because we have bullies. We have difficult personalities. We have people with issues. They want to control. How do we manage that then? Is our job to balance power, or is our job to resolve? Is our job to be impartial, or is our job to resolve? I know it's not in and or, it could be both. Is our job to take one side and help justice take place, or is our job to resolve? I cannot give you lecture on that. I cannot. You and your culture has those answers. And I'm waiting. I'm really waiting for African wisdom on mediation to be widely published. I know there are some terrific books coming out. A couple of my colleagues from Uganda have come out with a book. And I'm waiting for the global audience to accept African wisdom on mediation, because you have the answers. We have just started thinking of it in the last 20, 30 years. You've been thinking about it for the last 300 years, 500 years plus. So in conclusion, I'm just a servant of the process of mediation. Had a pleasure teaching some people in this room around the world. I am deeply troubled with what's happening in the world today. I'm an empath, which means I get troubled with the energy in the world universe. And as a mediator, I wish I could do more to stop what is unnecessary. What can you do to propel mediation to a stage where you can also stop what is unnecessary? And with that, what can you promote that is necessary? It is a beautiful concept. It gives us inner power. It gets close to the Eastern wisdom of contentment, mindfulness, peacefulness, ahimsa, right? The word that Mohandas Karamchand Gandhi used, borrowed from Jainism, a faith in India that originated in India, ahimsa, the non-violent movement. The power of that word is not with me, not with Gandhi, not with one person, it's with all of us. We have to believe in it and it becomes powerful. So today is the word. At this very moment, we need to go back to ahimsa. We need to go back to the idea of mediation. So I congratulate all my brothers and sisters who are involved in organizing this conference. It could not have come at a better time. I apologize one more time. I couldn't make it this person, but I also have promised I will be there next year and will be attending the entire event. I'll be there with my new book, which will be my gift to you, on cross-cultural intelligence, how to resolve conflicts. In the meantime, accept my brief remarks because I don't want to continue too much on Zoom. If I was in person, I would speak longer. But right now, I'm going back to my brother, Mr. Hauha. I have been blessed to be invited, and I thank you all.
Thank you, Professor Singh. Kindly allow me, Professor Singh, to invite the Honorable Minister of Justice and Constitutional Affairs to appreciate you on behalf of Government of Uganda. Honorable Minister, kindly come and speak to Professor Singh.
Thank you so much. Professor Singh, good to see you again.
Good to see you, Justin.
I am the student who was nicknamed Tom Sawyer in, in the class. The fact that I could graduate with a master's in dispute resolution is a sign that you can truly perform miracles as a teacher. Because I was juggling so many things. Now, for those of you who do not know Professor Singh, he is based at Pepperdine University. Pepperdine University is located in the city of Malibu. Malibu is in California. It's a very beautiful place. The campus of Pepperdine is very beautiful. And Pepperdine University perhaps hosts the leading program on alternative dispute resolution in the world. And the class that he taught alongside other professors was comprising 11 students, and all the students were totally different. There were 3 of us from the Ministry of Justice. There were 2 from, I could say, the private sector, and then 6 from the judiciary. And it included the 2 top judicial officers, namely the Chief Justice and the Deputy Chief Justice. So when in future you hear me boasting that, you know, I am an OB to the retired Chief Justice, and I'm also an OB to the former Deputy Chief Justice, I call them my classmates, don't be jealous. I'll only be speaking the truth. The course was very intense. It was also special because it required the class to host a conference. That was some hard work. The Chief Justice was so clever, he delegated the Deputy Chief Justice to lead the whole effort. And Deputy Chief Justice Butera